Welcome to our Shorthand Lab channel, Legal Dictation at the speed of 100 to 110 words per minute. So be ready. Start. In the first appeal, the High Court found that no evidence was adduced by the appellant to show that she had no independent sources of income. It has also come in evidence that at the time of death of the husband of the appellant, only Ram Mohan was 16 years old and the other children of the appellant herein were minors and they had no income. The High Court found that evidence was adduced to show that the husband of the plaintiff had substantial income and he owned an ambassador car. In view of this evidence, High Court held that properties at items 1 and 2 are joint family properties. The learned counsel for the appellant contended that without any evidence, the High Court came to a finding that the husband of the plaintiff number 1 had substantial income. From the list of the documentary evidence produced before the trial court, nothing appears on record to indicate that there was any document evidencing the income of the husband of the plaintiff number 1. Therefore, the High Court fell into an error by holding that though the properties at item numbers 1 and 2 are recorded in the name of the appellants, they are joint family properties. Section 14(1) of the Hindu Succession Act, hereinafter referred to as the Act, has a bearing on the issue. As the properties at item numbers 1 and 2 are recorded in the name of the appellant, in the absence of any evidence to the contrary to this case, the appellant by operation of section 14(1) of the said Act is the full owner of those properties. In the facts of this case discussed above, it has to be accepted that those properties are not joint properties, but the appellant is the sole owner of those properties. The principle laid down in section 14(1) of the said Act has been read by courts in a very comprehensive manner, since the said Act overrides the old law on Stridhan in respect of properties possessed by female Hindu. The Honorable Apex Court held that section 14(1) of the Act contemplates that a female Hindu who in the absence of the said provision would have been a limited owner of the property will now become full owner by virtue of the said section. Such female Hindu will have all powers of disposition to make the estate heritable by their own heirs and not revertible to the heirs of the last male holder. A 3-judge bench of this court reiterated the position that the said Act has overriding effect and confers full ownership on Hindu female and made it very clear that rights conferred under section 14(1) to a Hindu female are not restricted or limited by any rule of Hindu law. In the opinion of the court, the said section makes a clear departure from all texts of Hindu laws and rules, and those texts and rules cannot be used for circumventing the plain meaning of section 14(1) of the said Act. Thank you so much.